Thank you for inviting me to do this, including me in this wonderful panel. So welcome to the Young Legal Scholars panel. I'm Josh Teitelbaum, and I'm going to serve as the moderator. We have a terrific lineup of five bright young legal scholars who will present unpublished working papers and receive comments from a brilliant senior legal scholar, Richard Epstein. So first, let me introduce our panelists, starting with our five presenters. And I'm going to do that just in alphabetical order by last name, although that's not the way we'll proceed, and I'll explain that in a second. So Judd Campbell is an assistant professor of law at the University of Richmond School of Law. His academic focus is First Amendment law and constitutional history, and today he will present his paper, The Invention of First Amendment Federalism. Jonathan Mitchell is a visiting professor of law at Stanford Law School and the former Solicitor General of the state of Texas. He's published articles on national security law, criminal law, judicial federalism, and stare decisis and constitutional adjudication. And today he'll present his paper, The Writ-of-Erasure Fallacy. Lochlan Shelfer, I'm losing my home place. Lochlan Shelfer is a litigation associate in the Washington, D.C. office of Gibson, Dunn, and Crutcher, where he's a member of the firm's appellate and constitutional law and administrative law practice groups. His academic focus is constitutional history, federal courts, and the history of federalism in ancient and modern legal systems, and his paper is entitled Intergovernmental Federalism Duties. Megan Stevenson is an assistant professor of law at George Mason University's Antonin Scalia Law School. Her research uses advanced econometric techniques to evaluate criminal law and policy in areas such as bail, pretrial detention, juvenile justice, and risk assessment, and she will present her paper, Assessing Risk Assessment. And finally, Lyle Weinberger is a PhD student in the Department of History and a JD student in the law school at the University of Chicago, where he studies American legal history. Lyle's current research focuses on American lawyers' ideas about international law, world order, and human rights in the first half of the 20th century. His paper is entitled, and he wins the longest title award, Rebellion Against International Law, Law, Ideology, and the Bricker Amendment. And finally, Richard Epstein will serve as our commenter. Professor Epstein is the Lawrence A. Tisch Professor of Law and Director of the Classical Liberal Institute at New York University, and the Peter Kirsten Bedford Senior Fellow at the Hoover Institution, and the James Parker Hall Distinguished Service Professor of Law Emeritus and a Senior Lecturer at the University of Chicago. As we all know, he is among the greatest legal thinkers of our time. He's written countless articles and books on a wide range of legal and interdisciplinary subjects, and he's among the most cited and influential legal scholars of the 20th and 21st centuries. And so this panel is very lucky to have him commenting on their papers. So we're going to hear from the presenters in two groups. Group one will be Jonathan Mitchell, Megan Stevenson, and Lyle Weinberger, and they'll each have 12 minutes to present. And then we'll hear from Professor Epstein presenting his comments on the three papers, and he'll have 21 minutes. And
21 minutes, I may not take them.
That's fine. And then more time then for the audience Q&A. I've reserved 12 minutes for group one. And then group two will go Judd Campbell and Lochlan Shelfer, 12 minutes each again. Professor Epstein will comment on those two papers for up to 14 minutes, leaving 8+ minutes for audience Q&A on group two. My job is over except to try to keep us on schedule. I'm not, as my kids will tell you, I'm not the strictest of disciplinarians, but I will try my best. And so without further ado, let's hear from the first presenter, Jonathan Mitchell. And I'll try to signal to you. Yeah.
So the language that we use to describe judicial review will often imply that courts have a power to formally revoke statutes that they believe to be unconstitutional. Whenever a court declares a statute unconstitutional or enjoins its enforcement, it's common for people to say that the statute has been struck down or rendered void. And it's common for the Supreme Court to use terminology of this sort when describing the effects of its rulings. As a result of this rhetoric, it's often assumed that a judicially disapproved statute ceases to exist as a law. People think that the court has struck down the statute or rendered it void, and they view it as an act akin to an executive's veto. And the political branches will often respond as though the court's ruling has effectively erased the statute from the law books. My claim is that this way of thinking about judicial review is mistaken, even though it is widely held. And I further argue that this language that we so often use to imply that the courts wield a writ of erasure over duly enacted statutes is more than just a rhetorical mistake. It has also improperly augmented the powers of the present-day judiciary at the expense of the political branches and at the expense of future courts. Judicial review does not empower the courts to formally revoke or suspend legislation. It allows the court only to decline to enforce a statute in a case before the court, and it allows the court to enjoin the executive from enforcing that statute. But the statute continues to exist, even after a court opines that it violates the Constitution, and it remains a law until it is repealed by the legislature that enacted it. The power of judicial review is no different in this regard from a presidential edict not to enforce an act of Congress. When the president determines that a statute violates the Constitution and directs the executive not to enforce it, he does nothing more than present the enforcement of the statute while his order remains in effect. The president's order does not strike down the statute, nor does it invalidate the statute, and the statute remains federal law, notwithstanding the president's refusal to enforce it. Those who violate the statute in these situations assume the risk that a future president might repudiate his predecessor's non-enforcement policy, and they assume the risk that a future president might choose to prosecute those who violated the statute while the predecessor's non-enforcement policy was in effect. If President Obama declared the federal ban on partial birth abortion unconstitutional and directed the executive branch not to enforce it, that would not in any way preclude President Trump from enforcing the statute against those who violated it during the Obama presidency. Judicial pronouncements of unconstitutionality are no different. They are temporary, they are always subject to repudiation on appeal or by a future Supreme Court, and the temporarily disapproved statute continues to exist as a law until it is repealed. All that a court can do is announce its opinion that the statute violates the Constitution, decline to enforce the statute in cases before the court, and issue injunctions that prevent executive officers from initiating enforcement proceedings. But the court's instruction to the executive lasts only as long as the judiciary adheres to its belief that the statute violates the Constitution, just as a president's non-enforcement order lasts only for as long as the president decides to keep it in effect. Those who choose to violate a duly enacted statute in reliance on a judicially imposed non-enforcement policy remain subject to statutory penalties, just as those who choose to violate a statute in reliance on an executively imposed non-enforcement policy. To give one example, Citizens United did not strike down the federal statute that imposes criminal liability on those who use money from a corporation's general treasury for electioneering activities. The statute still exists. It hasn't been repealed, and it's still a federal crime to violate this statute. All that Citizens United means is that the government won't currently bring criminal charges against those who violate the statute because the government knows that its indictment will be dismissed by the federal courts. But Citizens United might be overruled someday. And if it is, the government can resume enforcing this statute against anyone who has violated it. Citizens United is nothing more than a judicially imposed non-enforcement policy. It has not repealed and it has not canceled the underlying statute. There are a lot of implications that follow from this, and some of the implications are more controversial than others. In my brief time, I'll focus on the implications that I regard as the most provocative and the most likely to generate discussion. First, the political branches can do much more than they are currently doing to push back against court rulings that, in their view, wrongly enjoin the enforcement of their duly enacted statutes. For example, both Hillary Clinton and Bernie Sanders, when campaigning for president, promised to appoint Supreme Court justices who would overrule Citizens United. Had either of them won the election, they could have filled Justice Scalia's seat with a jurist who would have done exactly that. But candidates Clinton and Sanders could have gone even further. they could have announced that they will criminally prosecute any person who violates the statute that the Supreme Court declined to enforce in Citizens United if and when the Supreme Court overrules that decision. Imagine if just one of those candidates had made a promise of that sort during the campaign. Would you violate this federal statute that imposes criminal liability in reliance on a Supreme Court decision that might be overruled? If there's even a possibility that a future court might repudiate the decision enjoining enforcement of a law, then the mere threat of future prosecution by the executive or mere saber-rattling by individuals seeking election to public office might be enough to induce substantial, if not total, compliance with the statute during a period of judicial non-enforcement, even if the case is never overruled and even if the threatened prosecution is never brought. Here's another example: preliminary injunction orders. Because of forum shopping opportunities available to plaintiffs, it's quite common for litigants who challenge the constitutionality of a statute to win a preliminary injunction in front of a friendly or hand-picked district court judge, only to see the injunction vacated and the law upheld on appeal. If a statute provides for criminal or civil penalties, then the government can announce that it will impose those penalties against anyone who violates the injunction, or who violates the statute, that is, while the preliminary injunction remains in effect, if the government succeeds in having the preliminary injunction vacated on appeal. An announcement of this sort has the potential to induce some or total de facto compliance with the statute, notwithstanding the preliminary injunction, because anyone who violates the statute during the period of the injunction will have to assume the risk that a future court might overrule the preliminary injunction and allow prosecutions to proceed for past conduct. Now, there are some obvious limitations to using this strategy. I'll mention a few. First, many statutes contain statutes of limitations that prevent the executive from bringing criminal charges or civil penalties after a period of time has elapsed. So if a judicial injunction has been in effect for a long period of time, the executive won't be able to go back and prosecute people who violated the statute outside the limitations period. Second possible limitation is a criminal defendant or a civil defendant in litigation might try to assert a mistake of law defense or a constitutional due process lack of notice defense if the government were try to seek penalties against those who violated statutes in reliance on a judicial pronouncement of unconstitutionality. But the legislature can obviate many of these obstacles in the statutes that it enacts. Suppose the legislature is considering a law that is certain to be challenged in court. It could be a campaign finance law, it could be an abortion restriction, it could be a state law prohibition on sanctuary cities, many examples you can think of. If the legislature is drafting a statute knowing that it will be challenged in court, then the legislature can provide in the statute first that the statute of limitations will be tolled during any period of judicially imposed non-enforcement. Second, that there will be no mistake of law defense if someone chooses to violate the statute in reliance on a judicial opinion of unconstitutionality that is later found to be erroneous. And third, that anyone who chooses to violate the statute during a period of non-enforcement remains subject to civil and criminal penalties if the non-enforcement policy is ever lifted. The writ-of-erasure mindset seems to have left the political branches unaware that options of these sort are available to them, even when the political branches vehemently disagree and disapprove of the judiciary's decisions not to enforce their statutes. Now, I'm not going to go so far as to say that the political branches should use threats of this sort or should threaten to pursue statutory penalties against everyone who violates a statute that a court has said violates the Constitution. Right. Whether and under what circumstances this tactic should be used depends on a variety of factors, and some might conclude reasonably that this tactic should never be used. The strongest situation for a threat of future prosecution would involve situations in which the public policy furthered by the disapproved statute is very strong, and in which the constitutional reasoning used by the court is weak. Those are the most plausible scenarios for the politicians to respond to judicial pronouncements of unconstitutionality with maneuvers of the sort that I've described. There's another important implication that arises in the field of criminal sentencing. The Supreme Court, as we know, has interpreted the Eighth Amendment to impose many limitations on the state's ability to inflict capital punishment on certain categories of offenders. They've also limited the state's authority to impose life imprisonment without parole on certain categories of juvenile offenders. When the Supreme Court issues rulings of this sort, the typical response from lower courts is to vacate the previously imposed sentence and re-sentence the defendant to a lesser punishment. That remedy reflects writ-of-erasure thinking. The Supreme Court has never struck down the statutes authorizing these punishments. The Supreme Court has not formally revoked those statutes, and the Supreme Court has not permanently outlawed the states from imposing or inflicting these punishments in the future. All of these Supreme Court decisions mean is that the current membership of the Supreme Court at this moment in time regards the punishments authorized by these sentences as in excess of the constitutional limits provided in the Eighth Amendment. The way to respond to a Supreme Court ruling is not to vacate the death sentence or the sentence of life imprisonment, but to suspend the sentence until a time at which the Supreme Court repudiates the previous constitutional objections that it had to that punishment. Legislatures also can establish regimes of conditional sentencing in response to Supreme Court rulings of this sort. Kennedy against Louisiana, for example, held in a 5-4 vote that the Eighth Amendment prohibits the death penalty for child rapists. A state that opposes Kennedy against Louisiana can enact a statute that allows its courts to continue imposing capital sentences on child rapists who are convicted, but that provides that the sentence will be suspended and cannot be carried out unless and until the Supreme Court overrules Kennedy against Louisiana. And I'll stop there.
That's scary.
Thank you very much. Megan Stevenson.
Papers on exactly the same topic.
Yes. Criminal justice risk assessment tools are computer-generated algorithms that predict the likelihood that somebody is going to commit crime in the future. You take some basic input, such as the criminal record, someone's age, maybe their zip code, their education level, their employment status, and the algorithm will classify that person as low, moderate, or high risk. These predictions are then used in courtrooms across the country to determine pretrial custody status, the length of the sentence, the level of probation supervision, whether or not someone's allowed out on parole, and so forth. Like Philip K. Dick's Minority Report, people are being punished for crimes they have not yet committed. Proponents of risk assessment argue that by replacing the ad hoc and subjective human intuition with scientifically validated tools, we can lower incarceration rates without affecting crime. It's not uncommon to hear wildly optimistic claims. In one recent Harvard study, the authors argue that they could lower New York City's jail population by 42% without affecting crime by using their risk algorithm. However, risk tools are becoming increasingly controversial. Many people are uncomfortable with leaving important life-altering decisions up to computers. Furthermore, some people think these tools are racially biased and will worsen racial disparities in criminal justice. No risk assessment tools directly use race as an input variable, but many of them use socioeconomic variables that are correlated with race. Even the criminal record is influenced by racially disparate processes. If you live in a heavily policed neighborhood, you're simply more likely to get arrested than if you'd committed the same act but lived in another neighborhood. So the debate over risk assessment has unfolded with rancor and histrionics, but very little knowledge. Even though risk assessment tools are dubbed as the preeminent example of evidence-based criminal justice, there is virtually no evidence on what actually happens when these tools are adopted. The evidence-based moniker is simply due to the fact that these tools are associated with big data and statistics, and that social scientists have performed fancy policy simulations that suggest that they should be highly effective. But transforming a policy that should be effective to one that actually is effective is not always straightforward. The same human foibles that proponents of risk assessment point to when they're arguing for their adoption complicate their use in practice. Context, incentives, and details of implementation matter. Yet the scientific veneer of risk assessment has created so much flash that somehow the research community has failed to answer the most basic question. Does use of this tool improve outcomes compared to the status quo? In this paper, I provide some of the first evidence on the impacts of risk assessment in action. I focus my research on a state that has been cited as a leader in pretrial reform, the bluegrass state of Kentucky. Kentucky was one of the earliest adopters of pretrial risk assessment and is widely considered an example of best practices and a model for other states to follow. Kentucky has had some sort of pretrial risk assessment in place since the 1970s, but it was not widely used. In 2011, they passed a law that made the pretrial risk assessment mandatory and declared a presumptive default of immediate release for all defendants that are classified by this risk tool as low and moderate risk. Using a highly detailed microdata set on more than 1 million cases, I analyze how this law impacts incarceration rates, failure to appear in court, pretrial crime, and racial disparities in detention. I also analyzed another important change to Kentucky's use of risk assessment. In 2013, Kentucky switched from their homegrown risk assessment tool to one that has since become the dominant tool across the United States, the PSA. The PSA was designed and promoted by the Laura and John Arnold Foundation. It was piloted in Kentucky and has since become adopted in dozens of jurisdictions and 3 entire states. Here are some of the main results. First, the 2011 law did result in a change in practices that led specifically to an increase in releases for low-risk defendants and a decrease in releases for high-risk defendants, much as it was designed to do. This chart here shows the change in the percent released among low-risk defendants, moderate-risk defendants, those for whom, due to technical reasons, had no score, and high-risk defendants. And as you can see, an increase in releases for low-risk, decrease for high-risk, and a sort of moderate increase for moderate-risk defendants. However, judges ignored the presumptive default more often than not. Even though the statute said that all low and moderate risk defendants should be released immediately with no monetary bail conditions, only 32% of judges only followed this presumptive default for less than a third of defendants. The next 3 points are all sort of demonstrated with the same graph, so I'm going to talk through them quickly and then we can look at the evidence. So although there was a change in the types of defendants that were released, the 2011 law led to only a small net increase in the pretrial release rate. Over time, judges seemed to sort of stop using the risk assessment tool. They returned to their previous bail habits. And the introduction of the Arnold Foundation's risk tool, the PSA, basically had no effect. So this chart here shows a time trend in the likelihood of the fraction of defendants that are granted pretrial release. The vertical axis shows the fraction of defendants that are released. This horizontal axis just shows dates. So here you can think in January 2010, about 67% of defendants are released within 3 days, and so forth. So this dotted red line refers to when this 2011 law, which is called HB 463, was adopted. And this solid red line is when it was implemented and made sort of mandatory. So you can see some of the change happened when it was passed through the Senate. You can see that there is definitely a noticeable jump up in the release rate, but it's only about 4 percentage points. And then the release rate continues to decline. The PSA is adopted. Basically nothing happens, and it continues to decline. And within a few years, the release rate is actually lower than it was before the risk assessment was made mandatory. All right. So unfortunately, we didn't see the big efficiency gains that proponents of risk assessment had promised us. In addition to the slight uptick in pretrial releases, there's also a slight uptick in failures to appear, which is often called FTAs, and pretrial rearrest. after the 2011 law. So this is a time trend. It's sort of similar concept to what I showed previously, but this is the fraction of defendants that have an FTA, at least one FTA. Here again is the introduction of this 2011 law. You can see there's a noticeable jump up. It's small in magnitude. It goes from about a little over 7 percentage points to almost 10 percentage points. But relative to the baseline, it's quite a large jump proportionally. And once again, not that much happened around the PSA. Here is a similar time trend in pretrial rearrest. This one's a little bit noisier. It certainly didn't go down. It looks like it went up a little bit. And once again, not that much around the time of the PSA. So finally, it's a little bit more complicated, but the short story with racial disparities is that risk assessment had no impact. There was some change, there was some differences across regions, and so the graph I'm going to show you is adjusting for regional trends. But once you've adjusted for some regional trends, you don't see any difference in the likelihood, in the gap, the race gap in pretrial detention. So this graph right here shows the pretrial release rate. Up here it's for white defendants, down here it's for black defendants. Once again, I've adjusted for regional trends, so this is kind of a deviation from the mean, and it's also, since we've taken time trends out, that's why the lines are flat instead of declining. You see a pretty constant race gap in the likelihood of being detained pretrial at about 5 percentage points throughout the entire time period of my analysis. 1 second. All right. So despite big claims on both sides about what risk assessment would bring, in Kentucky, really nothing much happened. And what did happen was not a unilateral improvement. I want to reiterate here that this is a study of risk assessment in action, which is basically definitionally a joint study of the tool and the way that it was used. The impacts of risk assessment depend on context, incentives, and details of implementation. Many factors are relevant here, such as the fact that judges are elected, not appointed, the fact that they faced little formal evaluation, and that they faced no costs in terms of ignoring the tool, et cetera. The results I present should not be taken as definitive evidence that risk assessment is useless, but rather as suggesting that maybe we should temper our expectations a little bit. Risk assessment is not a magic bullet that is easily going to solve the problems of overcrowded jails and prisons with no adverse consequences. There are trade-offs. Usually have your cake and eat it too policies are too good to be true, and until there has been solid replicated evidence that risk assessment can lead to large efficiency gains, I would be suspicious of any such claims. Second, the Kentucky example should temper but not eliminate concerns about risk assessment and racial disparities. While risk assessment tools may embed some racial biases, they may not be worse than the status quo method of making decisions. However, this question should be continued to be examined in other jurisdictions. Third, those who are hoping to use risk assessment as a method of lowering jail rates and liberalizing release need to either convince or coerce judges to cooperate. On the face of it, Kentucky's 2011 law looks very pro-release and was written with the express intent of lowering their exploding jail populations. In that regards, it certainly failed. Judges were not on board. Smart policy needs to take judicial incentives into account or minimize judicial discretion. And then finally, evidence-based criminal justice should be more than a catchphrase indicating that it is associated with big data and scientific-sounding techniques. It should be a careful and iterative process of trying new things, testing to see if they worked, making changes if need be, and evaluating again. Risk assessment may eventually prove itself to be a valuable tool, but figuring out how to turn its potential into reality will take research and experimentation, an accumulation of evidence on what works and what does not. Thank you.
And next we'll hear from Weinberg.
All right. The United States has long had a complicated and troubled relationship with international law and international legal institutions. On the one hand, the United States is one of the pillars of the global legal order, a nation that has made institutions like the United Nations possible through its financial support and military enforcement. On the other hand, Americans are often notably hostile to international law and international legal institutions. The United States has been exceedingly jealous of its sovereign prerogatives to act on its own without international interference. It has been suspicious of many human rights instruments, of global institutions like the International Criminal Court, and the list could go on. Observers generally think of conservatives as the critics of public international law, usually because conservatives believe that the United States and its legal order and its constitution are in some sense exceptional. Less sympathetic observers tend to gloss this as something akin to xenophobia. In any case, American opposition to international law and legal institutions takes many forms, and it's often tempting to think that this has been a constant in American history, but it hasn't. The American legal community, in particular, went through a strongly internationalist phase in the early 20th century across partisan divides, and it wasn't until mid-century that this internationalist consensus was destroyed and the modern politics around international law began. So my research exploring this forgotten history is really an attempt to explain and understand how we arrived at the modern set of concerns, attitudes, and critiques that have shaped America's relationship with international law, public international law specifically. And it's really picking up in an area where historians of the United States and the world have most historians have left off. There's been a lot of research in the last 10 years about the internationalists who played an important role in drafting human rights instruments, designing the United Nations system, and things of that nature. There's been a lot less attention to the conservative critiques of that. So today I want to make 3 points. First is that American lawyers across partisan lines were quite likely to be internationalists in some sense in the first decades of the 20th century, and indeed to think that international law and international courts specifically were going to be the major American contribution to world order. Second, that it was in debates surrounding a failed constitutional amendment in the mid-20th century, the Bricker Amendment of the 1950s. It was then that the American legal profession for the first time expressed widespread hostility to international law and legal institutions. And third, that crucial concerns driving the Bricker Amendment were intellectual concerns about how the international law field itself had changed. Other historians who have studied the Bricker Amendment have mostly emphasized its connection to American racism and opposition to civil rights and to the Cold War era, both of which are essential to the context. But there is also this intellectual aspect that I think is really crucial for understanding the modern American politics of international law. So just to elaborate on each of these 3 points very briefly. The forgotten background brings us back to the 1910s and 20s when American lawyers were building on a few decades of gradually increasing interest in international adjudication as a replacement for diplomacy. The basic idea was a somewhat utopian hope that legal rules were going to replace the messiness of case-by-case diplomatic relations, and that law would gradually fill the domain of international relations, and the world would be much more rational and much more orderly. This idea became quite popular in the State Department, which was staffed largely by lawyers. Its high watermarks were in the Hague peace conferences of 1899 and 1907, and it continued into the World War I era and its aftermath. Now, we normally think of this era as one of American isolationism because Woodrow Wilson had his plan for the League of Nations, the Senate voted it down, and the United States stayed out of the global, of the first attempt at international legal institution. What is really forgotten, though, is that many of the critics, especially if they were lawyers, the reasons for critiquing the League of Nations was that it wasn't law-based enough, and that even very outspoken critics of the League, like William Borah, were fans of an international court. And indeed, every Republican president of the 20s supported American participation in the Permanent Court of International Justice, which was the League of Nations connected court. So rather counterintuitive. That view continues through the neutrality debate leading up to World War II and through World War II, with some fluctuations that we could talk about in questions and answers if anyone's interested. But we get to the post-World War II era, and it seems like the internationalists have now achieved some things that they were excited about. We have the creation of the UN, we have the International Court of Justice. There you go. Thanks. And but just on this apparent victory, American lawyers become disillusioned. And that's when the Bricker Amendment grows out of this. The critique begins in really 1947-48 as some American lawyers in the American Bar Association look at the draft versions of human rights instruments that are being circulated and the attempts to draft the Universal Declaration. They begin to worry that this is becoming an un-American document that is conceding things to the Soviets, that there are changes to the American philosophy of rights. And Frank Holman, who becomes president of the American Bar Association in 1948, begins to speak frequently and loudly against the UN and its attempts to expand international law. His critiques gain the attention of the Senate. Senator Bricker from Ohio sponsors a U.S. constitutional amendment that comes very close to passing and has widespread support until Eisenhower comes into the battle, concerned that this is going to reduce the prerogatives of the executive. The motivations here, one important and very unsavory motivation was that many Southern lawyers and Southern senators were concerned that the UN was going to interfere in American race relations and mandate desegregation. Non-Southerners tended to worry about the Cold War and international legal institutions becoming tools of the Soviets. But the forgotten component is that many of these lawyers had concerns that international law had just expanded its ambit, that its regulatory potential had grown significantly, and that the real concern here was centralization, that we were going to repeat the New Deal or something like it through international legal institutions. There was a lively conversation about the Supremacy Clause. There was a lively conversation about the potential for U.S. courts directly enforcing treaties passed that originated with the UN and directly enforcing them in the United States. And many of these concerns have actually stayed with us into the modern era. The Bricker Amendment failed in the Senate, but it was a turning point. The anti-internationalists lost the battle for the amendment, but they did win a victory, because in order for Eisenhower to win a victory to defeat the amendment, the Eisenhower administration had to concede had to make concessions that it would no longer pursue ratification of certain human rights instruments, no longer pursue ratification of the Genocide Convention. And in the years leading up to the Bricker Amendment, the widespread internationalism that we saw was largely gone by the end of this. The voices in the foreign policy establishment of the United States shifted to criticism and suspicion of these public international law instruments. The Bricker Amendment's designers had succeeded in placing the anti-international position on the ascendancy, extracting commitments from the Eisenhower administration that would guard American sovereignty and independence. Internationalism would not die, but would have to fight hard for any advances in the decades to come. That, I think, is the key legacy of the Bricker Amendment, and it leaves us with a lot of continuing issues regarding the continued effectiveness of treaties on American law and the popular resonance of public international law in the United States. Thanks.
Oh my God. I'm going to sit down so I can look at this ominous clock, which beats off. I have more than 21 minutes to say, and therefore I will not say them all. And let me take the papers in order. I think it's obvious they two things about them in common. One, this is an incredibly heterogeneous lot. I mean, the order is arbitrary, the connections are non-existent. And that's a sign of strength of the academic community, that it can move in so many directions at the same time. It is also a nauseating truth on the part of my part to see how much hard work people put into these papers, because it makes me very uneasy of the slapdash techniques that I've managed to use for scholarship for the past 50 years, and I think I'm too old to reform, so I will just announce my envy in principle to everything that they've done. Talking about the papers, however, let me start with Jonathan, my former student. And Jonathan always puts the fear of God in me, because God forbid he should be right on this particular question. And now why do I say that? Well, first of all, although he did not mention who his major adversaries were, one was a guy named John, as in Marshall, and the other was a guy named Alexander, as in Hamilton, both of whom were trained and accomplished lawyers, and both of whom decided to use the word void with respect to those actions which they thought exceeded the scope of the particular Constitution. And so the question is, why is Jonathan right when the other two are wrong? And what he does is he makes a very powerful formulist case, that is this guy, that essentially no court has the power to strip a statute out of the statute book, so there it sits. The question, does it sit there as a landmine which is likely to explode at some future time, or is in effect the whole thing stripped so that while it's still on the statute books, it is now in some sense a dead letter? And the question is, which way do we prefer this? And as ever, when I start looking at constitutional issues, I think quite clearly about various private analogies to what's going on. And there are many cases where the technical application of a particular statute in private law does not extinguish a particular obligation, but renders it only unenforceable. That is certainly true with respect to the statute of frauds. You can't compel a conveyance, but if there's a voluntary transfer, it's good. It's also true about the statute of limitations, that it prevents the action, but if the payment is made, you can't get the recovery one way or another. It's true of many things in bankruptcy law. And the question is, what happens to these things is most people become very uneasy about the gap between the unenforceability on the one hand and the voidness on the other hand because of what they perceive to be, quite rightly in my view, the really dangerous collateral consequences associated with some of these things. So if this statute is still on the books, think of it in the public law context, it turns out that the president has decided, the Congress has decided that certain conduct ought to be criminal, but they cannot, in fact, enforce them. Well, to give you an illustration of a case where this becomes positively kind of instructive, is what you do is you have a statute like the one in Smith against the Employment Commission, and what goes on there is you get non-enforcement by the criminal side, and then somebody inside the Department of Employment says, gee, this conduct turns out to be criminal, so what I'm going to do is deny these guys benefits, at which point the net consequence is perhaps the single worst opinion that Justice Scalia wrote in Smith, which sustains that particular element. But what happens is you don't want to have a situation where it's a loose cannon, because one of the things that could happen with respect to the situation that John talks about is as follows. We still think that this particular statute is, in fact, is constitutional. So now when we start giving out various grants to people, what we will do is announce that anybody who does not understand the unconstitutionality, or rather the constitutionality of our statute, is in fact not going to be able to get any public monies. So take any of the statutes that he starts to refer to, and sure enough, if it turns out you're talking about Citizens United, and you don't want to play the game in accordance with the way in which we think it ought to be played, they know this is after Hillary is president or whatever it is, it turns out that what we will do is we will just won't give you any grants. And the question is, do we really want to have a world in which direct enforcement is blocked, but the question of having grants coming through is something which remains exclusively in the executive prerogative? And I think most people would say that this is an enormously dangerous type situation because what it does, in effect, is it kind of keeps the landmine alive. Jonathan, I think, is well aware of this particular problem. And so at the one hand, you say, this is the way it is, and on the other hand, God forbid anybody should ever use this. And I think that that's a serious point. The second thing is about the in terrorem effect. If the statutes are still on the book, and then what you do as a Democrat, you come across and you announce, you know, if we ever get into power under this thing and we ever get to reverse this, we're going to treat everything in the interim as though it is going to be illegal. You really have a terrible in terrorem effect that will take place with people, because now, in effect, what you do is you have somebody on the Supreme Court who says that the conduct is indeed perfectly permissible to make political contributions. But on the other hand, if you do it and we get into control, we can do it. Jonathan then says, oh, but there's a statute of limitations. And then, like Job, he says, the Lord giveth, the Lord taketh away, blessed be the name of the Lord. We could always toll the statute of limitations so that we can continue to go after you. And I think what was going on in cases of this sort was a real appreciation about the effect you don't want this kind of stuff to ever happen because it creates an impossible sort of political environment. And now let's just sort of do it in another way. So we had a modest revolution on the scope of the commerce power in 1937. I'm just going to give you one case. There's the famous case of Hammer against Degenhardt, which essentially says you cannot use control over the instrumentalities of interstate commerce to enforce a child labor statute against activities that are themselves local. For a variety of reasons, I always thought it was a correct decision. But now what happens is you get United States against Darby, and what we do is we say, you know, this statute case is overruled. So can we now go back and punish everybody for violations of this particular statute years after the thing is passed in a completely different environment? I think the answer to that question has to be no. I think it also has to be, no, can you enforce the Civil Rights Act of 1875? Because by the time you get to the 1974 statute, this thing is there. My view is I think you want to treat them as dead letter and require the new Congress under contemporary circumstances to say it. So I agree that this is a very difficult technical issue. I come out in the opposite direction. Now, turning next to Megan's paper, I'm going to start with an anecdote because all of my detailed empirical information dates from my childhood. And I could recall my father, who was a radiologist, had to hire people. And I was about 14 or 15 at the time. And what he told me was that the hospital had put into place a scoring system, which would allow you to put numerical parameters about all of the people that you could have so you could make an executive decision to hire. And my father's reaction to that is, I want to hire Jones. You tell me what numbers I have to put in the various boxes so that Jones comes out number one, and I will do it. If you think that I'm going to listen to you, give me a set of independent numbers, to hell with you. And in fact, what happened was we saw in this particular case, a case of, all the relevant people are dead, a situation of just kind of massive resistance to the imposition of that. And then the question you start asking is it right or is it wrong? And let me sort of give the technical reason why I'm not sure and why Megan is not sure. What you do on these things is you take a kind of an algorithm and you put n things into it, right? And then you get this residual term. And the residual term is essentially a blank box. And if you're, a left-winger, you treat it as a function of discrimination. If you're a right-winger, you think it's a function of institutional, incurable incompetence of one sort or another. It turns out that both of these things are wrong. Any decent specification will probably say that there are a number of other variables that it's difficult to invent in time. If you put them into this particular equation, it would probably give you a better R squared than if you took them out, at least in many of these cases, but we don't know what they are. So what the intuitivist is saying, I don't think the set of variables that you put into this particular equation is robust enough to do it. I, as an intuitionist, essentially have always looked at A, B, and C, and I just don't think, since you address these things, that you're right. So it's not just a question of being perverse. It's also a question, to some extent, saying that your empirics, like most empirical studies, are necessarily incomplete. There's a very nice article by Jim Heckman in the 1998 Journal of Economic Perspectives and so forth, where he says most of the findings that you get about discrimination are all with respect to residual variables, and all of them are with respect to underspecified equations. So you really have to be enormously careful about the way in which you want to go after these kinds of things. And I think that's a serious problem that one has to worry about in all of these studies. Now, it also turns out in these particular cases, what Megan says is, I think, 100% correct. And essentially what she has done is to take the poetry out of the great expression, many a slipped twixt cup and lip, meaning, in effect, the implementation of these things is done in a decentralized way by a group of individuals for whom oversight is essentially functionally impossible. And so what she did is she basically introduced something which I was taught many years ago by a very smart insurance executive named Dick Schmaltz. And what he did is he talked about the half-life of a statute. And what he meant by that term is you put anything you want on the books, and the forces of granular erosion will start to take place here, there, and the other place. And so what you have to ask yourself is, how many years is this thing before it's going to either collapse or it's going to be propped up by a series of judicial interventions that are so improbable nobody would have ever done it? Well, what Megan has proved to us is that the half-life in her statute is about 1.5 years, right? But that's a kind of a lesson I think that everybody has to take into account when they do these sorts of studies, and to realize that the conclusion that she comes to at the end of this situation is that sunny misplaced optimism based upon empirical research is in fact a very serious issue. And this, of course, goes not only in this particular area. The phrase evidence-based, as far as I'm concerned, is used by many people as an effort to stifle dissent, because we now get to the situation where the people in the agency, say the FDA or the old EPA, and say, we have done evidence-based research. You, Professor Epstein, just talk out of the top of your head and you don't know nothing. And my attitude about it is I can return the compliment. What's wrong with evidence-based medicine in many cases, or evidence-based anything else, is that there's no theory that informs the empirics. That is, one of the truly dreadful features of modern empirical research is that it's perfectly open. There's a perfectly clear theory which says if there's a real gap between the minimum wage on the one hand, which is higher than the market rate, you'll get dislocation. And everybody sort of forgets that when they start doing the empirical research without bothering to ask the question whether in any particular jurisdiction the market wage is above or below and how much of the equilibrium stuff. So the empirical stuff is essentially worthless because they can't control for the things that you have to do. Whereas the little old me, I just put a diagram on the board and say, hey, here's a serious kind of dislocation. Explain to me why it's wrong in theory. And they said, well, you didn't read the Card-Kruger study, and which I could point, it's never been replicated anywhere else. So you have to be very, well, it hasn't been, right? I mean, you've got to be extremely careful about the way in which one does empirical research. And I've gotten to the point now where I'm almost in open rebellion against this because, I mean, you get studies of the grand sort which says, well, regulation has no effect on the way business goes because we ran a study on this. Well, you ran a study on regulation in a market with 9 billion regulations in a given period. We have a different 9 billion regulations in a different period. Why is it that there's any transferability? In effect, I have another naive theory, which I spend my life on. If you interfere with voluntary transactions between parties on the opposite side of the market, it will produce social losses. None of these studies seem to take that very seriously, which is why it is, I think, in the end, that most of them are seriously wrong. So I commend Megan for doing all this. The last point I want to mention is what do we do about race? I think the public response to this is something of a disgrace. Somebody says, well, gee, this may have racial impact. And what she says is, the current system may have racial impact. Nobody is willing to actually study that question. And so the question you'd want to ask is if Megan put in a dummy variable for race, would it come out that it turns out black, white, Hispanic, or whatever groups that you wanted to do this, you can find the trend. And there's absolutely nothing a priori to say that if you're going to get something like this, it's going to be anti-black or anti-white, right? I mean, you just don't know. And so what happens is everybody keeps this in this void because dummy variables are not to be allowed, which means that we just have systematic ignorance. And that is, I think, a really dangerous situation because when you start looking at other markets like insurance markets and mortgage markets, you can see a lot of cross-subsidies the moment you put the race back in, and they tend not to be in favor of white individuals. They tend, on average, to be in favor of minority groups. And I think you just have to understand all of that rather than allowing this pervasive charge of discrimination to take place when there's zero evidence of it by the very empirical metrics that these people start to say is important. You can't have it both ways. And you cannot say we want evidence-based evidence, but on race it's so clear we simply don't know what's happening. You've got to be able to do a lot better than that, and I could give you theories which would point the directions in both ways so that it is an open question. Now, the last paper is the one that Lael wrote, and obviously it's closely related to the two previous papers. And I want to start with something that he had in the paper, which he didn't put in there, which was Florence Allen. Now, I first met Florence Allen, again, everything is anecdotal, in Boris Bitke's tax class. Judge Allen had written a very strong opinion in tax, and Bitke let it down on his class, mainly 85 to 95% male. She was a woman. She was. It turns out she was the first female ever appointed to the appellate courts of the United States. She was, in fact, an extremely able judge, and she had been an activist in the progressive movement in favor of one-worldism in the period that Yale had pointed to. Well, the question is, what's going on? And what he didn't give you in the discussion is to explain not why the Southerners on segregation were this, and that was a bit phony. The Bricker Amendment stuff's 52, 53. Brown v. Board of Education was at least 2 decades in the future, i.e. 18 months, and so forth. This was going to happen one way or the other. What was it about the progressives that made them so much opposed to what's going on? And I think what Yale has to do in this paper is he actually has to look at that godforsaken document known as the UN Declaration of Human Rights. Parts of it are perfectly fine, but like every one of these declarations, they're always completely schizophrenic. On the one hand, you've got this libertarian declaration about individual rights to choose this, that, and the other thing, and it sounds as though they're defending markets and autonomy and freedom of choice and freedom of religion. Until you then find that all of this stuff is completely consistent with mandatory unionization on the one hand and a bunch of other stuff. And what happens is this thing is an intellectual disgrace because they couldn't decide exactly what to put in there. And so like all of these documents, one way or another, they have both things. You want to see the contradiction? Look at any statement made by any university on why we treasure freedom of choice, that everybody can believe in social justice, but how dare you decide to oppose us on A, B, and C having to do with this. It's a deep tension. And everybody on both sides of the issue understood all of that. And so Florence Allen, what she said, to be quite clear, I thought this stuff about international law was having a world peace arrangement so that the courts could prevent war from happening. I have no interest whatsoever in having these guys try to decide on what workplace justice and unionization is going to do. I think that's a local issue, and I think it ought to be decided that way. And she was perfectly principled. She didn't care which way it went out on this thing. She thought it was just an impossible intrusion. And I think, in fact, she was right. Now, politically, what has happened, and Yale doesn't mention this, but it's worth mentioning, I think, because it's extremely important with respect to this period. You didn't mention the 1946 election, right? Now, what happens in 1946 in the United States is the Republicans gain about 14 senators, and the Republicans gain 80 seats in the House of Representatives. The Republicans are able to put through the Taft-Hartley Act. The Administrative Procedure Act actually gets bipartisan support, but it's all essentially a reaction to the New Deal. They thought they went from 0 to 10. We're scaling you back to 7. I would have scaled you back to 0, but nobody asked me. I was 3 years old at the time, in my opinion, although very well formed, was not very well articulated. And all of this stuff weighed very heavily on everything that went on because the mood that had taken place was essentially against administrative adventurism on the part of the United States. And when you start looking at this international stuff, you can see the same kinds of things starting to take place without any of the political checks that are associated with this country. And so what is said here is, in fact, exactly correct, but you have to understand what's going on in this particular case. If, in fact, you're starting to deal with the United States, yeah, we're great cooperators. And to the extent that we can throw our weight around and we're not going to be bound, we will essentially do what every powerful country does, which is to agree to be bound by the regulations that we want to be imposed on others. This is in the ideal world. It doesn't always play out there. So that we're a good citizen when we do this. But we're not going to play a game in which everybody who hates us can now outvote us, whether it's in the United Nations or anywhere else. And I can still remember in 1954, you did not put this in your paper, I had a debate in which I had to defend the United States as membership in the United Nations. And I had to debate a fellow named Donnie Block, who was so incredibly smart in ninth grade I could have killed him. And he wiped the floor with me, pointing out all of these kinds of difficulties. And I sat there, and it was one of the first lessons in my life, which says that when you look at political institutions, as I think is being done here, you never look at these institutions strictly and solely as the way they exist on paper. What you have to do is to figure out who is going to populate them. And so I'm going to give you first the contract analogy, and then I'm going to give you the law analogy. You have two contracts you can do with. One is a sketchy agreement with somebody you trust, and the other is a very precise and detailed arrangement with somebody you don't trust. Which of the two deals do you take? And the answer is you always do business with the people whom you trust. You never do business with a formal contract with people you don't trust, because everything that's designed to protect you can be turned on its head and screw you. So that's the rule. Same thing applies with respect to these international transactions. You will not put yourself into a forum where you're a minority against everybody else. And the reason Eisenhower got this stopped is when John Foster Dulles went before the Senate, he conceded that everything they said in the Bricker Amendment was stuff, was correct, and so he said, you don't need it because we've already surrendered. And you know what? Eisenhower was right to surrender to keep his prerogatives, and I would be right to surrender the rest of my time because I am now a trespasser. Thank you.
Thank you.
Okay.
All right.
All right. Last two papers.
So before we move on to group 2, I want to reserve time for questions from the audience for group 1 or for Professor Epstein. Yes, I'm sorry, I don't know your name.
Gene Bullock.
There you are.
We have a mic, if you don't mind using it. Yeah, that way people
It's being recorded.
remotely can probably get it better.
So I have a question for Jonathan, and maybe your draft deals with this, but what would you do with regard to a statutory construction decision? So this court says the statute means X. It looks like it might mean Y or might mean X. We think it means X. Some people think it's a total stretch. Some people think it couldn't possibly mean X, but that's what we think. And off I go and I do my business and I assume that it means X. And then I get prosecuted, and I say, but the court said it. The court says, nope, sorry, we changed our mind. So do you think there would be either kind of a sound policy problem with your general proposal if it were applied there, or a due process clause problem? And then the follow-up question, as you might gather, is, if the court's decision about unconstitutionality is by looking at the overall legal system, which is the statute plus the Constitution, which is the supreme law of the land, we conclude that the right way of interpreting is by saying the constitutional prohibition binds rather than the statute binds. Why is that different? And relatedly, even if despite that you do think the two are different, and maybe you think they're the same, but if you do think the two are different, wouldn't that mean that it would yield very hugely different results depending on whether a court says we're interpreting the statute in light of constitutional doubt or we're actually striking it down?
Yeah, I think the same logic carries over to the statutory construction context. And normally the Supreme Court's decisions interpreting statutes are made retroactive. I mean, at the very least, they're made retroactive to the parties to that litigation. And it does raise some questions. Antitrust law, they might overrule an antitrust precedent on which the parties have relied, but they're still going to apply it to those parties to the specific case. Now, on the normative question, should the political branches go back and use their prosecutorial discretion to penalize people who relied in good faith on a previous court ruling, or should civil litigants try to bring lawsuits against those people? I think it will be a context-dependent question on whether it should be used. And I think one could reasonably conclude that it should never be used. I think someone who's a judicial supremacist would be loath to allow the political branches to try to use threats, such as the ones I mentioned during my discussion, to try to undermine the efficacy of a Supreme Court ruling. But I think that depends on a prior commitment to judicial supremacy. Others, I think, might think these people relied on the judiciary's interpretation. It was a reasonable interpretation. They couldn't expect for it to be overruled. Therefore, we shouldn't prosecute them. But in other situations, Citizens United, everyone should be able to see that Citizens United could be overruled someday, given the intense criticism that it's engendered. Right? So there will be different. I think the issue will be different depending on the context.
If I could just follow up, you spoke about antitrust. I don't know if you meant criminal antitrust. What I have in mind specifically is the criminal persecution context, and whether you think there would be either due process clause objections or overall policy objections to your entire proposal in the statutory construction context, because that would arise a huge amount of the time. And one question is whether the due process of law means that you get to rely on
there could be.
Decisions.
So the way the court's cases say it right now, and it's hard to get a general principle out of what the court has said in these different contexts, but the Supreme Court has said that there can be a due process defense to a criminal prosecution if you relied on a previous judicial decision and the repudiation of that decision was unforeseeable. And one specific example I can give is Marks against the United States, which involved the federal obscenity statute, where the pre-Miller construction of the statute was being used and relied upon by someone who was peddling obscene material. The court later changes its interpretation in Miller, and then they go back and try to prosecute these guys. And the Supreme Court said, no, you can't do that, violates due process, because first, this was an unforeseeable change in the law. And second, the court also goes on to say this is the First Amendment where we have special concerns about notice. So from what I've gathered from the court's current set of cases, a due process defense would be most likely to succeed in a situation where you're seeking criminal sanctions for First Amendment activity or expression type of activity in a situation where the change in the judiciary's interpretation could not have been reasonably foreseen. That will be the strongest situation for a due process case. But the court's never gone so far as to say the due process clause gives you an automatic defense if we change our interpretation of a statute. It's all very, that's, I mean, I'm just saying as a descriptive matter, that's what the Supreme Court has said.
I'm going to make a couple of comments on this. First of all, on the descriptive side, one of the cases to look at would be Saccone Vacuum, which was an antitrust prosecution for essentially cartelization of the market when they had the problem with the hot oil. And what makes this case so distinctive is that the particular scheme that was subject to criminal prosecution was in 1935 or 6 expressly urged upon the various producers by the United States government to stabilize the production of oil field, and then Thurman Arnold comes in and changes his mind and he brings a criminal prosecution, and in 1940 Justice Douglas says there's no particular defense at all to that particular thing. A terrible decision. There are also the whole retroactive jurisprudence stuff. Connolly and Gray in the mid-1980s are Reagan-era decisions where essentially you get explicit authorization and they can basically take it away from you, and it's not an impairment of contract. The part of Jonathan's normative formulation that I take violent exception to is that if changes are foreseeable, you're not protected against them. The whole point of giving yourself some kind of protection is to make sure that the government cannot do the foreseeable if it turns out to be iniquitous. What you want to do is to make sure that there's a stability of expectations, which you can't possibly have if the government could announce the day that it loses a case, we're going after you 100%, so you can't rely on this because it's going to be foreseeable that we're going to change it. I think what happens is it induces intolerable behavior on the part of political figures, which we should not have. And the last point, just the kind of, well, to figure this stuff up, is you're starting to work on the normative grounds. One of the things to understand is right now, modern administrative law allows for huge flips with no explanation. And I regard that as completely indefensible. The rational basis test doesn't even give you the defenses of a business judgment rule. And the correct answer in all of these cases, you want to switch. In a world of Chevron, you better give an explanation. And that's been explicitly repudiated, I think, multiple times by the Supreme Court, most recently this past term.
So, John, I'm sure you'd want to respond, but I want to get some more questions.
Yeah.
My question's also for Jonathan, though I thought all the presentations were very interesting. I was just curious if your paper looked at the difference in remedies versus facial versus an as-applied challenge to a statute, because in an as-applied context, say there's a broad keeping the peace statute, and the court has said applying it in a way that is punishing speech based on content is impermissible, but we would completely expect that statute to stay on the books, as opposed to if a statute were facially written to prohibit speech based on its content. I think right now, Westlaw itself would recognize, that law has been invalidated by a court judgment if such a court decision were made. So I'm just curious how that played into your analysis, if at all.
Yeah, I tried to stay away from the normative question of when facial versus as-applied remedies should be imposed. I think your question, though, relates to what happens if you're dealing with a reliance on a decision that only gives an as-applied remedy versus a facial remedy. I don't really see any difference there. In both situations, there's always the possibility that the court could repudiate what it previously said, and when it makes that repudiation, they will be saying what the law has always meant from the get-go. Now, again, just to clarify, I'm not in any way suggesting that the courts, the political branches should be going back and retroactively prosecuting people in these situations. My claim is, as a descriptive matter, they do have the prerogative to do so in certain situations. And the writ-of-erasure fallacy has caused people to think that they never can do this because the statute has somehow been suspended or temporarily erased, or that it was struck down by the court ruling. If there are arguments to be made for why we shouldn't be allowing these types of post-court decision enforcements, we need to make arguments for why they shouldn't be allowed, sort of along the lines that Richard is making, because it would upset reliance interests. But we shouldn't be just assuming that they can't be brought because the statute's been erased. So whether it's facial or as applied in terms of what the court previously did, in either way, the statute as written continues to exist as a statute. There's always the theoretical possibility that what the court said about the statute and its constitutionality could change, and the statute continues to exist as a law during that period of time.
I have one comment. If it's an as-applied challenge, the statute still survives.
Right.
And so it clearly has to be, to that extent, at least a difference.
Yeah. But my view is the statute always survives. I mean, when the court says facially, they'll say we're striking it down. They're not striking it down. They can't do that. That's just an imprecise shorthand for saying we have categorically enjoined the enforcement of the statute. So one of the claims I say in the paper is we should just never say invalidate We should never say struck down. We should never say nullify when we're talking about court rulings that simply enjoin the executive from enforcing a statute that continues to exist, whether it's facial or as applied.
Do you overrule Marbury v. Madison?
No, I don't overrule Marbury against Madison. I might tweak a few of the words in the Marbury opinion.
I think we have time for one more question.
Diplomatic.
I have to apologize. This question is also for Jonathan.
I'm sorry.
It's only because
You
the
can answer it.
other papers aren't in my area of experience. I was going to say, it seems to me that Marbury doesn't require really any tweaking. I mean, the whole point of Marbury is that the reason that the statute is not given effect is because the Constitution is contrary to it and is superior to it. And the statute can stay statute even as legally it's void because it's trumped by something else.
Yeah.
It strikes me that a lot of the reliance concerns that you're worried about are to some extent handled by the existing doctrine of stare decisis, which looks to reliance as one of the reasons to consider. But it seems to me that the paper might be on stronger normative ground to reemphasize that, look, the law is what it is before the court ever ruled. So if something was criminally prosecuted, and it really is a crime, and it's something that Congress can constitutionally prescribe, and the courts say, the courts refuse to allow those prosecutions to go forward, they can't sort of change the rule, they're making a mistake, there are lots of ways to deal with that. The president could pardon somebody. We have lots of other tools in the toolbox. Congress could pass a statute granting some sort of immunity to a lot of people. There are lots of things they can do to handle that problem, which does not necessarily require a special judicial intervention.
Yeah.
On the flip side of that, though, I wasn't sure how that model would apply to criminal sentences, because it doesn't seem to me that the correct remedy is to suspend a sentence. It would seem that the lower court, after the Supreme Court says this sentence is unconstitutional, the lower court, by reasons of vertical stare decisis, has to assume they're right about that. And so it ought to vacate an unconstitutional sentence rather than suspend it, and it ought to resentence.
Well, let me answer the second part first, if I could, because it's the punishment that's unconstitutional under the Eighth Amendment. Cruel and unusual punishments are what's prohibited, not cruel and unusual sentences. So the constitutional violation cannot take place until the punishment is inflicted. So if you're talking about, I'm sorry.
Isn't an order that compels an unconstitutional action legally flawed for that very reason? Like, isn't that a good reason to vacate an order because it orders somebody to do something that would, if done, be unconstitutional? I
don't think so, because the constitutional violation won't happen until the order is carried out. So if the order is merely authorizing something that the Supreme Court thinks is unconstitutional, the order can continue to exist as long as it says that it's suspended until the Supreme Court changes its mind. So on the timing question, when is the Eighth Amendment actually violated? The violation occurs when the punishment is inflicted, not when the sentence is imposed.
Okay.
This is the sort of subjects of the Constitution type argument, the who and the when, who violates the Constitution, when's it being violated. So that's the premise of my Eighth Amendment argument, because the punishment.
Is that unique to the Eighth Amendment? Because suppose that a judge, just out of the blue, out of nowhere in a case, orders one party to do a little dance. And the party seeks mandamus and says, I shouldn't be made to dance. And it's not that it's cruel and unusual punishment. This is a civil case about land, and I have no idea why they ordered me to do this. It would seem like there's good argument for vacating the order because it would be unconstitutional or otherwise illegal to compel you to do the thing the order is ordering you to do.
Right, but what I'm saying with the suspended sentence, it's not ordering that the sentence be carried out. It's just authorizing the sentence. And because you're suspending it, the order
that's true of criminal sentences.
Yeah.
A lot of them direct the.
Then we should create a mechanism where you can have a sentence carried out like that. Because the problem is, if you formally reduce the sentence to 50 years rather than life imprisonment, then double jeopardy prevents you from going back after the Supreme Court overrules Graham against Florida and going back to the sentence that you could have had, even though by overruling Graham against Florida, the Supreme Court's saying this is what the Eighth Amendment meant all along. And our earlier predecessors were wrong to say that it forbids life imprisonment in these situations. So that's why I'm urging the creation of this mechanism, even if you're right to say that what we currently have in criminal sentencing doesn't allow for this type of thing. So your earlier point, I think, was on Marbury. Should I stop talking?
Yes.
Okay. Can we talk afterward?
Yes.
Okay.
Well, let me have one sentence. I think that the particular situation in Marbury, where the Supreme Court said we don't have jurisdiction, generally the consequence of not having jurisdiction is that the actions are void. And so the question is, does a writ-of-erasure fallacy apply to that case as it does to issues of judicial supremacy as opposed to judicial parity?
Yeah. And of course, Marbury says the statute is void,
Yes.
which that can be interpreted in different ways.
Yeah, but I think in effect your thesis works less well with Marbury than with judicial supremacy.
Yeah, I think that's right.
Okay.
All right, well, thank you very much to Group 1. Now I'd like to hear from Group 2 and Judd Campbell first.
All right, thanks so much to the Federalist Society for hosting this and for inviting me to join in the fun. I'm presenting a history piece, and the story begins in the summer of 1798, which I believe is before Richard has any personal anecdotes, but I guess we'll see. So the United States was on the brink of war with France, and the Federalists controlled all three branches of the federal government. And they decided to pass a Sedition Act, which made it a crime to falsely and maliciously criticize the government. And in response, the Jeffersonian Republicans made a slew of arguments against the act, including the argument that under the First Amendment, the federal government was categorically barred from regulating expression at all, whereas state governments had some room to regulate harmful speech under their own speech and press protections. In other words, Republicans understood the First Amendment not as an ordinary guarantee of rights, but instead as a rule about the allocation of power between the federal and state governments. That is, that all restrictions of expression have to occur at the state level. So the paper is making two primary claims. The first is Republicans are making a new argument, even though they're casting that argument in historical terms. And the second argument is that the reason why Republicans are making this new argument is that they were confronting a new problem, and particularly the problem of the development of political parties and the phenomenon of partisan jury selection by federal marshals who were appointees of the president and who would stack federal juries with fellow Federalists. And these developments left conventional speech and press freedoms nearly useless for Republicans, and so the imperative of party politics in the late 1790s required that they come up with something new. Now, the history is important to modern constitutional debates in a variety of ways. For instance, it calls into question any modern reliance on the the Republican opposition to the Sedition Act as being indicative of the original meaning of the speech and press clauses. The fact that Republicans were making these novel arguments in historical originalist terms also might give us pause about considering post-ratification evidence when thinking about questions of original meaning. And then this history also, and this actually dovetails with the point that Richard was making at the very end of his comments on Lyle's paper, the history highlights the importance of concerns about biased enforcement in the context of First Amendment doctrine. And I think we see this sort of concern reemerge in the 20th century, particularly in the civil rights era with cases like New York Times versus Sullivan, where the court is worried about biased Southern juries and it adjusts doctrine accordingly. All right, so the first part of the paper provides a brief overview of where things got started. I'm making an argument about change, and so I need to set the terrain for where the speech and press freedom stood in the late 1780s. I've done that mostly in another paper called, just published, called Natural Rights in the First Amendment. And so for present purposes, I'll just highlight three key takeaways from that project. So first is that although there are a range of founding era views about exactly what speech and press freedoms did in terms of limiting governmental authority, very, very few people thought that speech and press freedoms imposed this sort of categorical restriction on any governmental power to regulate expression. Second, the argument for federal protection for speech and press freedoms was that those protections would be the same as state-level speech and press freedoms. In fact, the whole point of a federal Bill of Rights, according to the anti-federalists who were pushing for it, and then the federalists who eventually accepted it, was that state governments had rights protections, and the federal government needed those rights protections too, in order to limit the means of federal power. Third point is that conventional understandings of speech and press freedoms in the late 1780s principally channeled decision-making in sedition cases and other libel cases toward juries. And this aspect was central in the minds of Federalists and Anti-Federalists alike. Alexander White of Virginia stated that, quote, "Should I be unjustly accused of sedition, the trial by a jury of my countrymen is my security." Samuel Bryan of Pennsylvania said, quote, "If I use my pen with the boldness of a freeman, it is because I know that the liberty of the press yet remains unviolated and juries yet are judges." So ideas about speech and press freedoms are not categorical. They're assuming parity between state and federal protections, and they're channeling decision-making toward juries. So then how do we get to Madison's statement, for instance, in 1800, that the First Amendment, quote, "was meant as a positive denial to Congress of any power whatsoever over speech and press"? When is it that Republicans change their view? And my argument is that the Republican view begins to shift in 1797, a full year before the Sedition Act, when a grand jury in Richmond issued a grievance presentment, which was basically a form of public censure against a congressman named Samuel Jordan Campbell. And it's really a tragedy of American history that Campbell never got to be a talk radio show host because he was actually born for that role. He said in January of 1797 in a public letter that Federalists were, quote, "hastening with a precipitancy and frantic rage only to be equaled by its depravity and madness, the attainment of the darling wish of the aristocracy of this country, the establishment of monarchy." And then he concluded the letter by saying that Americans were, quote, hurling us into the vortex of tyranny. And so Virginians, who were still a genteel bunch at this point, decided they didn't like this much, and the grand jury in Richmond censured Campbell for having written these seditious letters. And this led to a huge backlash by Republicans. So the grand jury presentment, as I said, was simply a censure. It wasn't an indictment. It wasn't an initiation of criminal charges. So why were Republicans so upset? And the key point here, I think, is that they woke up to the precarious position that they were in with respect to jury selection. The grand jury in Richmond was hand-selected by David Meade Randolph, who was a Federalist appointee. He selected his brother to be on the jury. He selected the presiding judge's brother. He selected a former U.S. Supreme Court Justice, John Blair. He selected several members of the state legislature, several Federalist merchants, and so forth. And so Republicans began to realize that the conventional speech and press protections that channeled decision-making toward juries were going to be nearly meaningless if juries were chosen on the basis of their politics. And we see this concern clearest in Jefferson's writing. So when Jefferson heard about the Campbell presentment, he engaged in his typical sort of over-the-top thinking, and he decided that he was going to petition the Virginia legislature to impeach the grand jury and through the impeachment process impose sanctions. And so Jefferson said that this sort of interference was especially deserving of punishment because, quote, "grand jurors are selected by officers appointed and holding their places at the will of the executive." So when he proposed this in a private letter to James Monroe, Monroe suggested that actually this is a federal grand jury. Maybe we should send this petition to Congress. At this point, Jefferson came up with a really interesting theory to answer Monroe's objection. So he said that the natural right of free correspondence was not claimed by the Constitution, but was entirely a state concern. And here I think we see the seed of the federalism theory that Jefferson later adopted. But the point that I want to really emphasize is that Jefferson was constrained by the politics of the moment. So he privately told as much to Monroe. He said that doubts as to Virginia's jurisdiction had occurred to him too, but that sending a petition to the House of Representatives would make bad worse, then a majority of that House would pass a vote of approbation. In other words, he couldn't seek a federal remedy because the federal institutions were controlled by the Federalists. Now, the following year, 1798, the Federalists passed the Sedition Act, and this led to an incredible series of debates about speech and press freedoms. Federalists had a fairly conventional view. that so long as what they were targeting was false and malicious speech, that the act satisfied the constitutional requirements. Harrison Gray Otis, a Federalist leader in Congress, said that the act, quote, merely prohibits calumny and deception, end quote. And then he noted that a, quote, honest jury could distinguish the two. So the only consensus Republican response with respect to the First Amendment was that the federal government had no power over speech and press, and that sedition prosecutions should proceed at the state level. So over and over again, Republicans tied this argument to the problem of jury selection. So John Nicholas, just an illustrative quotation, said that critics of the government would, quote, have to be tried by juries selected by the marshal who also receives his appointment from the president, all of whose feelings would of course be inclined to commit the offender if possible. We see Albert Gallatin, Edward Livingston, and others making the same argument. And after the Sedition Act was enacted, Charles Pinckney described the power of federal marshals over jury selection as, quote, worse than 10,000 sedition laws. So the outcome of this concern was a denial of any federal authority over the press. This is the position of the Kentucky resolution. This is the position of the Virginia legislature in 1797, which said that sedition might receive its punishment in state courts from juries summoned by an officer who does not receive his appointment from the president. And Madison made the same point in the Virginia Report of 1800. But in all of these instances, Republicans were claiming fidelity to the original meaning of the Constitution. What they were doing was a form of constitutional updating in light of the development of political parties, but what they were saying was quite different. And I think we have a tendency to do the same thing when we look back on the Republican opposition to the Sedition Act. We often hold up the Republican opposition as a triumph for freedom, while forgetting that the overwhelmingly dominant Republican argument was all about federalism and not about rights.
11 seconds left.
All right.
Last we'll hear from Lochlan. Shelf, excuse me.
Hello, and also a big thank you to having me out here. This is a beautiful area. My paper is about the constitutional litigation that is increasingly happening between governments, either state versus state, or between a state and the United States. As we all know, this is increasingly becoming the forum, the channel for a lot of constitutional, 2 minutes left, for constitutional litigation, in no small part because of people like Jonathan Mitchell once was, Solicitor Generals across the country on both sides and different administrations are taking it in their hands that state versus United States or state versus state suits are the preferred place to bring constitutional challenges. And we've seen this in Texas versus United States, Arizona versus United States. We saw it with the ACA, where Virginia sued the federal government. And the difficulty with these cases is that there is unresolved questions about their justiciability. Because often these cases seem to just be asking, the state suing the federal government, asking a court to say, please declare something unconstitutional, and there's often very little discussion of the normal justiciability markers of standing, of cause of action, of political question doctrine, these other things that often block similar suits in other contexts. So there are many cases where the court simply asserts jurisdiction, courts assert jurisdiction and don't discuss justiciability at all. There are other cases that seem very similar where the court does discuss justiciability and will often find that there's no case or controversy here. And this difficulty actually goes back to the founding. Some of the very first cases that were brought in the Supreme Court's original jurisdiction were between two states, later between a state and the United States over their territorial boundaries, questions of political power. And from the beginning, the court wrestled with whether this is something that that federal courts can even hear. It didn't quite seem to fit into the normal categories of common law, equity, admiralty. Courts didn't really hear this in England, and indeed there are cases from the colonies that came to King's Bench and to equity courts in the 1750s and 60s, where the courts there essentially said that these are not questions that we can assert jurisdiction over. We can hear a contract dispute that sort of tangentially touches on some of these territorial boundary disputes, but we can't really come in and draw a boundary for you. That's not really a judicial court's role. And so now, today, if you look in any federal court's textbook or treatise, whether it's Hart and Wexler or Wright and Miller or any of these, there is a question about whether some of these cases are properly heard by federal courts. Now, of course, states often, and the United States often asserts that they can bring a case because they're a proprietor, like any other private party, and that's not really what my paper talks about. There's also parens patriae jurisdiction, which is pretty unique, and that's also not what I'm talking about. But I'm focusing on those cases where the two governments in the dispute are asserting their political power, are asking questions about who governs a certain territory, who regulates a certain activity or task. So if you go back to South Carolina v. Katzenbach in the 60s, that was an original jurisdiction case. A lot of these cases originally were brought as original jurisdiction cases, so it would go straight to the Supreme Court. And the court in that case famously did not discuss jurisdiction, and Alexander Bickel famously said that it was an outrage that the court should hear a case like this. This bears no relationship to the usual justiciability principles. And so you have these cases like that, or Oregon versus Mitchell, where the court simply asserts jurisdiction and decides the case, but never discusses that. And then you have other cases like going back to Georgia versus Stanton and Texas versus ICC and some of these other cases in the 20s where the court says we really can't hear any of these cases. So the question is, do federal courts actually have this power, and if so, why? And my paper is an historical paper, my claim is that federal courts do have this power, in particular the Supreme Court does have this power, but not for the reasons you might think, not because it actually falls into one of these categories of a common law, equity, or admiralty jurisdiction. My contention is that this is, in a sense, a fourth way, a fourth sort of dispute resolution mechanism that federal courts possess that has not really been identified as such. And it traces its origin not from King's Bench or equity courts in England, but instead through quasi-political, quasi-judicial bodies, beginning with the Privy Council in England, going to the Confederation Congress under the Articles of Confederation, and then finally to the federal courts. So if we go back to the time when we were colonies, when two colonies would have a dispute, whether a territorial dispute or a dispute about who can regulate trade with the Indians in a certain area, or who can regulate or who can tax a certain port. These disputes, whether strictly territorial or more sort of incorporeal distinctions over who has the political right over a certain race, that would go to the Privy Council. And the sort of king and council would sit there and hear a case. It resembled in many ways a judicial proceeding. There would be local lawyers from London there. They would have briefs and there would be oral argument, and then the council would decide the case, and it would go back. And there were several cases, both on territorial and more incorporeal grounds, that were decided in this way. Later, when the colonies begin to become restful, they sent petitions to the king asking for the king to draw the lines of jurisdiction between the colonial, the colonial authority and parliamentary authority. And many of these petitions took on some of the same characteristics of the petitions that would go to the Privy Council. And then finally, when we declared our independence, it was essential that we had a body that could also could look and decide these disputes between the different states. And this power was given to the Confederation Congress. The Confederation Congress would then create ad hoc sort of administrative panels to oversee these disputes when the two states would come together. And then during the formation of the Constitution, originally this power was going to be given to the Senate. And that kind of makes sense because it's not strictly, as I said, a judicial power. It's sort of a political power that had not traditionally been exercised by courts as we understand them. But in a last-minute change, it was instead consolidated with all other state party cases, and every state party or governmental case involving the United States was given to the Supreme Court. And that, I argue, is the source of the jurisdiction for all of these cases. But when we recognize the history of these intergovernmental disputes, it helps understand and describe the contours of what this jurisdiction looked like. It wasn't simply any case where there was any dispute between two states over anything or some assertion that some law was unconstitutional. It was fairly specific. It was when the states had a disagreement over whether either one had exclusive jurisdiction over a certain territory or activity or people or thing. And so if we see that as the antecedent to this sort of anomalous jurisdiction that I argue federal courts do in fact legitimately possess, then we can give some boundaries to what sorts of cases the court can hear. And so that a case like South Carolina v. Katzenbach or maybe Oregon v. Mitchell is a good example, where the fight was over who, was it a state or was it the federal government that had the power to set the age, the voting age. And the Supreme Court said, asserted jurisdiction without discussing jurisdiction, but asserted that states do have the exclusive power to regulate that particular activity. So that sort of fits in the mold of these Privy Council disputes. For the same reason, interstate territorial disputes for the same reason. Thank you. For the same reason, satisfy this antecedent jurisdiction. Now, one of the reasons I think this is important for two reasons today. One is, as I said, there are more and more constitutional cases being waged between governments. And two, the Supreme Court has increasingly, maybe for the past 30 or 40 years, been reluctant to take many cases in its original jurisdiction when the case strays outside of a water rights or territorial dispute or something that's fairly narrow and understood in that way. And what I would hope is that my thesis would help to help the court or help others to recognize that first, conceptually, there's very little difference between a territorial dispute and a more incorporeal fight over jurisdiction. And second, that when the disputes are cabined to what I call federalism disputes, essentially, who has the true power, whether it's vertical or horizontal federalism over something, then we can say, yes, some cases satisfy this, whereas other cases, like Massachusetts v. Laird, where Massachusetts just wanted to sue the federal government to say the Vietnam War is simply unconstitutional, not because we are asserting our own exclusive regulatory power, but instead just because the Vietnam War is just generically unconstitutional. There, in those sorts of cases, the Supreme Court has rightly denied jurisdiction. Thank you.
Which is a tribute to the fact that neither of our last two speakers have violated the principles of temporal trespass. Let me take these papers up in order and indicate where I agree and disagree with respect to both of them. With respect to the question of the invention of First Amendment federalism, I think one of the ways to sort of get your hand into this is to spend more time on the text than Judd is. Oh, I forgot to turn on. Than Judd has actually done. Congress shall make no law with respect to the establishment of religion or prohibiting the free exercise thereof. This was often, at least with respect to the Establishment Clause, read as a proposition which said there is a state monopoly over this. We're protecting their established religions, which remained until Massachusetts abolished it in 1833. So you could say, the First Amendment is in fact a jurisdictional provision which gets the federal government out of this stuff. And then you start running into difficulties with respect to the second one of these clauses because there's no monopoly issue that's involved with respect to the free exercise of religion. And the question then is, what do we think about this with respect to freedom of speech? Is it the monopoly of the first half, or is it the sort of substantive guarantee subject to exceptions, like all principles that protect freedom, on the other hand? And I do think that there's at least a thread of a textual argument that could be put in favor of the Republican position to shut down the federal government. But there's something else which is missing in this paper, which I think is very important, which casts doubt on this. Think back to a case in 1878, Reynolds against the United States, which had to do with the application of the Free Exercise Clause. There was no incorporation issue in that case because it was the direct application of the Free Exercise Clause to the territory of Utah. And what the Supreme Court did was essentially a huge morals exception into the First Amendment guarantee of speech in a decision that I still regard as one of these remarkable testimonies to the intolerance of the United States Supreme Court against alternative forms of practice and so forth. But if that's in fact a legitimate jurisdiction, the difficulty that you get with the jurisdictional argument, which says that the federal government can't get itself involved in this, is that it then leaves open the question of exactly what kind of control that the federal government has over various speech issues inside the territories, which, as you recall, in 1787 was a lot bigger issue than this thing was, say, today, because you're not just worrying about Guam and so forth. You're worrying about, basically two-thirds the continental landmass of the United States before the incorporation of various states. And I think it'd be really quite odd to say that the First Amendment was meant to get rid of that portion of the Constitution in the direct powers, which says that Congress can make needful regulations for the territory. So you're getting very close to sort of Dred Scott territory on this particular issue. And I do think that it is important in starting to think about the way in which this particular case starts to work, to ask the question of what happens when you take the debate out of federal-state relationships and simply have a federal government there without any obvious state competitor. This is also a modern issue. Just to mention two cases of this is the whole case about the question about the minimum wage law in the District of Columbia in 1923. You didn't have to worry about in that situation whether or not the federal government was intruding on the area of the state. There was no state to intrude upon. And just in case one wants to think about it, Heller is a case involving Washington, D.C. And if, as I think the cases can be made, the Second Amendment is a federalism provision, then it has no application there as well. So I think the whole territorial thing is one which is extremely important. And to get the story complete as an analytical matter, you have to do it. The second question is this thing sound or is it not sound? And here, what happens is, I think that what happens is Judd spends a lot of time justly on the jury issue. I don't want to think that this is unimportant. We all know that when they passed the Civil Rights Act in 1964, they wanted the EEOC decrees to be done in equity because they didn't want to have Southern juries engaged in nullification. It's also the case when they passed the National Labor Relations Act in 1935. There was a Seventh Amendment question as to whether or not you could have administrative enforcement of this particular statute. So juries have always been very much on the mind of everybody in talking about these particular issues. But there's another side of the particular question that I think is worth doing. The Federalist general proposition is that as far as we're concerned, if it's malicious and dishonest and false speech, it's not protected by the First Amendment. And of course, the authority they cite in support of that particular proposition is the opinion of Justice Brennan in New York Times against Sullivan, Lochlan, which says exactly the same thing, rejecting the Justice Black position, which says that the First Amendment is a total bar, not only against the federal government, which would be consistent with the Federalist position at the time, but now since we have incorporation, it would also be true against the state. I regard Justice Black as being on the lunatic fringe when it comes to that particular issue, precisely because I think a speech, like everything else, is a presumptive freedom, and that the libertarian notions with respect to force and fraud have to be read in to explain what freedom is. So fighting words may not do it, but direct assault certainly would. Securities fraud, defamation, and so forth are out from underneath First Amendment protection, except in certain cases having to deal with remedies. So what is it essentially that we have to deal with to understand why the First Amendment in this case kind of applies to these cases, but not, I think, in the way that Judd suggests? And I think what you have to do is to start look to another line of cases, which is the line of cases going through cases like Barron, Blatt, and Yates, and so forth, asking the question, when you start having malicious speech of one kind or another, is it going to be the kind of thing which would allow you to punish abstract advocacy, ideas that the Marxists are now trying to overthrow the country? So in a case like Dennis against the United States, you get a bunch of Marxists talking about the importance of the overthrow of the United States government. If you take the Federalist position, you could punish that. And I think what really has happened in First Amendment law is that we've introduced in one form or another a very uneasy remedial calculus which asks us to examine the trade-off between the severity of the threat on the one hand and the immediacy of the threat on the other hand. And abstract advocacy, which is not focused, is essentially going to get First Amendment preference, notwithstanding the fact that it's malicious, false, and all the rest of that stuff. And I think it's a line of cases that we're done with, but to basically do it, if you don't have that particular piece in there, it's harder, I think, to attack the Federalists, because at least at the abstract level, they were kind of consistent with the situation of a libertarian view, which says that defamation, falsehood, and so forth are out from underneath constitutional protection. You need to deal with the remedial side. Now, turning to the second of our paper by Lochlan and so forth, I think it's actually two papers, not one paper. I think the truly novel portion of this particular paper is not its American constitutional argument, but I think that there is a completely understudied period about the way in which the Privy Council in England actually interacted with colonial issues during that time. I disagree with his characterization of the Privy Council. When I was an English law student back in Oxford in the 1960s, you could always get back to this, the Privy Council was essentially the House of Lords putting on a different set of robes. And what you did is these were the guys who came along and were the kind of court of appeal with respect to disputes that took place inside, not the colonies at this point, but inside the Commonwealth. So it was common at that time, for example, to have a situation in which, cases in Australia would go to the Privy Council, and it was just an adjudicatory body. And I think that that's the way in which it was understood, and showing those cases and the way in which it sort of dispatches them to marshals and I think it's just an absolutely fascinating history. And my recommendation is that you make two papers out of this, one which deals with the history on its own terms. It also, I think, explains some of the other features. The English House of Lords was not just a court, it was a political body. And at the time of the founding, it had a lot more pomp than it did today. And so when somebody says, oh, we're going to put the power of adjudication in the Senate is basically the upper house, like the House of Lords. The House of Lords had a judicial sub-body, and they were thinking of that as the possible matter. And then they thought about it perhaps a little bit more and realized that it might not quite work. And so they put it into the Supreme Court with original jurisdiction. I don't think there's anything particularly odd about the way in which this stuff is actually going to be organized. In fact, I think it's kind of straightforward that you would want to have this sort of arrangement. And so then the question is exactly what sort of cases you have. And I think on the federal jurisdiction stuff, what Jonathan Harrison said on the war power stuff is actually very relevant to the question of how it is that we understand the Constitution and federal jurisdiction. The stuff in the Articles of Confederation which dealt with the direct application of federal source, had a Congress. It didn't have a judiciary. Come to think of it, I don't think it had a president, but I could be wrong on that. I'm not. All controversial. And so what happens when you're looking at the internal structure of the federal government, there basically was an early version of Winston Churchill, too little, too late. We have to really beef this thing up and worry about the way in which we put these things together. But the Articles of Confederation had a bunch of other provisions on the horizontal side, dealing with full faith and credit, dealing with privileges and immunities, and as best I can recall, there was no real dissatisfaction with those kinds of provisions because they understood that the need to create a free trade zone was something which was of exceptional importance then as in now, and this was the good part of the articles that did it. And so they reworked the language a little bit here. Paupers accepted, or vagabonds accepted, I guess is now gone, and all the rest of this stuff. And the language is smoothed up, but we see exactly what's going on. And so when it comes to the question about whether or not you're going to get federal jurisdiction to deal with the kinds of cases that we're talking about here, I think it's perfectly clear and obvious as to why it was that what they did is they decided that they were going to have a distribution of original and appellate jurisdiction. And the first thing, remember, is in one of the fatal compromises, I think it was a mistake, in 1787, inferior courts were such things as Congress should ordain and establish. If you try to establish, therefore, original jurisdiction for disputes between states and put it in the hands of a set of courts that may never exist, you cannot then say, oh, well, you could always go back to the state courts to deal with this stuff, because that would necessarily mean that you're going to give one state priority over another. And in fact, these difficulties, I think, are extremely important even today. So what they had to do is they had to put it in the hands of the United States as an original jurisdiction, because otherwise you would never have an authority which would be sufficient to govern this. What I think is then important as you look at this stuff is you then have to ask the question, what is the body of law that is going to be used in order to deal with these issues? I don't recall, correct me if I'm wrong, but I don't recall you talking about Erie and Tompkins in this paper, do you? Now, you should, because it seems to me to be an essential part of the story. Essentially, if you go back and you start looking at the Swift and Tyson view of the universe, the judicial power is the power to create law substantively to deal with these disputes. And there are many, many cases that the Supreme Court deals, particularly on territorial and boundary lines, where they're creating the substantive law. So you get a case of a boundary line between, I think it's Nebraska and Iowa, it doesn't matter. And what you do is you have this long discussion about the private law relationship between alluvion and avulsion, trying to figure out what these volumes are. And what they do is they quote Pothier, they go back to the Roman sources, they do all of this stuff. And the thing that you should understand about it is essentially they get it right. That is, this body of law is perfectly coherent. They don't then try to figure out which state is. It turns out they become very strong natural lawyers with respect to this stuff, who are quite willing to look at foreign sources, not political sources. They don't care about that. This is not the debate as to whether or not we worry about the Argentinian Constitution, but legal sources for figuring out the ways in which these things ought to be resolved. And it was essentially a very sensible thing. When you get to the following problem, which is what do you do when sort of Erie doesn't allow you to do this, then you're forced to choose between this state's law or that state's law, and that becomes essentially an impossible choice to do it. So if you actually are consistent with the notion that the federal courts are sort of like the Privy Council kind of overseeing it, it turns out, and I'm going to end on this note, that Erie v. Tompkins, amongst its many bad consequences, essentially makes it much more difficult to judge interstate disputes in the United States Supreme Court. I'm done.
Thank you very much.
On time.
So we've got another 8 minutes or so for questions from the floor.
Got a question for Judd. I thought that your discussion of jury selection was valuable and interesting, just as in terms of how the Jeffersonian Republicans confronted this issue. But I'm not sold by your big thesis that there's a change amongst those Republicans, partially for the reasons just laid out by Professor Epstein about the original meaning of the Establishment Clause, for instance, in the First Amendment there, but also based on what their views of natural rights were. If you go back and read Jefferson or Madison, a lot of times they talk about natural rights in terms of, in jurisdictional terms. They'll say, you know, the government just doesn't even have a jurisdiction to even be messing with this because this is a natural right. And they, for instance, you go back and look at Madison's memorial remonstrance address when they're trying to pass the Virginia Statute on Religious Liberty. He says, you know, there should be non-cognizance of this issue. And so, are you saying that there was a kind of absolutization of the free speech right? Is that the change that happened? Or, I guess I'm not fully quite understand. If you're saying that, I'm still a little bit skeptical for some of these reasons.
Well, so the thing that's interesting here is they're not absolute, they're actually doing nothing to protect speech. Rather, they're just saying this all has to go to the state level. And so they aren't doing anything actually to elevate protection for speech and press freedoms in a legal sense because everything is just going to go to the state government. So the point that you're making about the sort of origins and where things get started is something that I didn't spend much time on today, but have developed in this other paper. I'll just have two quick points of reference. So one is that Jefferson explicitly says that the federal government should have power to punish false statements in the 1780s. The second is that the House Republicans, the House Federalists actually pass an amendment to the United States Constitution, and this gets to Richard's point about differences with the Establishment Clause, that says that state governments shall not abridge speech, press, or free exercise rights. And so if one took the position that the Jeffersonians actually had a consistent position and that speech and press freedoms in the early period were categorical denials of power to regulate expressive acts, then that would mean literally nobody had any power to regulate any expressive acts under the House Amendment, which can't possibly be right. And in fact, the fact that there was no power, if you took the jurisdictional view of free exercise, the sort of natural extension of the Madisonian position that you're talking about in the 1780s, that amendment disestablished every state church.
Yeah.
That cannot possibly be right. And in fact, the Virginia legislature in the 1780s explicitly removed the jurisdictional language from Jefferson's bill because I think it's a dissenting opinion. It's just a minority opinion.
I have one quick observation. The Lord giveth, the Lord taketh away. One of the things that is not widely understood about New York Times against Sullivan is that the plaintiffs joined the local distributor with the New York Times, and in an independent decision of the then Fifth Circuit, it was held that there was no removal into federal court. If you took that case into federal court, $500,000 per pop turns out to be $5 worth of pop. And indeed, the problem about making these jurisdictional arguments is it all depends on who's in power at what particular time, and that's just not the kind of permanence that you want to think of as constitutional.
Let's get another question.
Question for, excuse me, Mr. Shelfer, and how this thesis fits into Article 3. If I understand it, what you're saying is that the sovereign cases from the 16th, 17th, 18th century were not law, equity, or admiralty. The case-denominated heads of jurisdiction in Article 3 are law, equity, and admiralty. Then there are the controversies, and the U.S. controversies and state controversies are in the controversies heads and not in the case heads. But my understanding is that at the time of the framing, the standard explanation for the difference between cases and controversies was that cases included criminal proceedings and controversies were just private proceedings. And a criminal case is a characteristic exercise of sovereign authority. That's the reason the United States doesn't have to have the kind of standing that a private person has to have, because the United States can vindicate the general interest in compliance with the law. So if cases are about sovereignty, and controversies are more about what Richard might call meum et tuum, just what belongs to who in sort of in a private kind of sense, contract and property and that sort of thing. Does the claim that those inter-sovereign proceedings fit into the controversy heads fit with sort of that indication from Article 3 about what the difference between a case and a controversy is?
Yeah, thanks. So I agree that that one of the ways people distinguished between cases and controversies was based on criminal versus, or all cases versus only civil, I guess you would say. I mean, there are a lot of theories about what the distinction is between cases and controversies. Clearly, there's an important distinction, and I also think it's clear that controversies do not include criminal proceedings, which is one reason that you can't, a state cannot prosecute someone, an out-of-stater, for instance, in federal court.
Right, in the original jurisdiction.
Or any jurisdiction. That's right. So yeah, I certainly think that's something, but I don't think it's the only distinction going on. I don't necessarily think it's the key distinction that case is the capacious and controversy is the narrow. Controversy in other drafts, they say disputes. They say it's a bit of an imprecise word. It's used in contradistinction, as you say, to case, which is then defined as common law, equity, admiralty. These are cases that courts hear, that the courts that we understand hear. And so seeing controversy in that in its history there and what sorts of disputes the framers obviously had in mind. My contention is that controversy, in some sense, is almost more capacious. It's not so limited. I think Andy Hessek has an article where he argues that controversies are not so limited, and so it could comprehend, for instance, state law cases where the federal court would not be able to hear the case because of lack of standing, for instance, because it doesn't fall into one of those three categories. So I would agree with that. I would say controversies is simply a less precise, broader word that's capacious enough to comprehend a number.
May I make a comment? I forgot to say this. I strongly disagree with this whole line of analysis. If you understand what the Privy Council is about, it was just an appellate court with jurisdiction over certain kinds of cases, and the sorts of cases it could hear were cases in law, there were cases in equity, there were admiralty cases, there were maritime cases, and so forth. And the reason this problem is less mysterious is they issued all of the remedies that were available in all of these kinds of cases. And so there's just no kind of puzzle as to why it is when the Supreme Court inherits what the Privy Council did, it has the same armamentarium of weapons. The thing to understand, and this is my English education coming through, when we read Privy Council cases, we said, oh, these are Privy Council cases, but if you're trying to figure out what their authority was, you didn't care. So for example, the Wagon Mound, perhaps the single most important case having to do with foreseeability and tort, was a Privy Council case. And nobody said, oh, it's a Privy Council case. It doesn't matter. Some people says it may overrule in re Polemis, which was a very much king case. So I think you're just pushing much too much weight on this, and that the sensible thing to say is you got the full set of remedies. You don't care which half it's under. It could be under one or the other, or both. But so long as it's under one or the other, why do you care? So I think you're making more difficulties for yourself on this particular point than the subject matter warrants.
Can I do have a quick response to that, if I may? So in the 18th century, I see the Privy Council as having three main powers. One is certainly the appellate power. Two is the power to annul or void colonial laws. And then three is this intercolonial dispute resolution. And these three heads were all sort of separately tried. The framers tried to separately give these three powers to the federal government. The first one they succeeded by giving to the Supreme Court appellate jurisdiction. The second one they failed by giving the power to void state laws. And then the third, I argue, is actually a separate head of jurisdiction that also they were successful in giving both to Federation
Congress. I mean, the fact that they don't have power to void state laws, this is basically Martin Hunter's Lessee all over again.
Right. Well, my only point is that the intercolonial disputes that I reference are not appeals. They are original cases that are brought that other courts did not feel they had jurisdiction
Well,
to
that's
hear.
because essentially what happens is when you got two states that are rival, neither of them is willing to take jurisdiction over a case in which it has to deal with the sovereign.
I mean, King's Bench and
I mean,
equity
look,
could
yeah,
not
One of the things,
assert
for
jurisdiction.
example, dual jurisdiction was very unhappy at those times. Will Bode wrote this wonderful paper on the takings clause, in which he basically pointed out the federal government did not have the power to exercise the eminent domain power in the states under the originalist stuff. Why is that? Because dual sovereigns can't have eminent domain powers. And so it's back to the territory problem all over again. And what they did is they solved everything because there's no case that the Privy Council heard that didn't involve things that you didn't want, that the Supreme Court didn't have. And so it had plenary jurisdiction over all disputes between states. And then it's the non-Erie problem, which explains the body of law that they're using. And they're using every remedy in the book. That's why Erie is such an ignorant decision that it's really quite painful.
I'm afraid we are out of time.
Oh, my God.
But I'm going to ask you to come and ask your question in private afterwards. I'm very sorry.
Oh, I'm sorry,
Let me
too.
thank Professor Epstein. Let me thank our 5 panelists. Thank you.